Hi, I'm Bill Powers. I'm an attorney in North Carolina, and I help people with different criminal type of matters, DWI cases, speeding tickets, things like that. And we answer questions for people based on postings on public forums, online forums, where people are asking general questions. And the purpose of this is to try to give you an explanation of how the system works and hopefully encourage you to possibly seek out legal counsel as it's oftentimes more complicated than you may realize. Now, this case is a good one and asks, do I have to get involved in a case from 20 years ago? And do I have a case for myself for pain and suffering? All right, well, maybe a civil case, maybe a criminal case. I suspect it's a criminal case where someone feels like they have pain and suffering and are worried about the case for 20 years, but let's see. Yesterday, I was contacted by a detective. He's working on a very serious charge involving child molestation that occurred 20 years ago. And this person seemed to be a victim, and this person's working through therapy. Do they have to cooperate with the police? And is there any way to deal with the pain and struggles that have caused me my entire life? Okay. Well, is it a criminal case? Is it a civil case? The answer is yes, it's both. And at our firm, we do help people with both types of charges, civil and criminal. Criminal involving, obviously, prosecution of a criminal matter with the potential of jail and probation and things. Civil, when lawyers refer to civil court, they're normally referring to suing somebody for damages, for sometimes it's lost wages, sometimes it's the permanent injuries or disfigurements, and there are times where there's pain and suffering. And on these particular type of cases, and we don't see them as much as we used to anymore, not that it doesn't happen, but they seem to be prosecuted much more quickly now, if that makes sense. First, when it comes to this type of felony, and indeed any type of felony in North Carolina, there is no statute of limitations, there is no statute of repose for bringing the criminal charges. Doesn't matter if it happened 2 years ago, 20 years ago, 50 years ago. And that's a serious felony. Normally it would involve some really high-level felonies, such as indecent liberties of a minor. There could be exploitation of a minor, distribution of pornographic materials, things of that nature and seriousness, where people go to jail or prison really for long periods of time. Secondly, do you have to cooperate with the police investigation? Well, if you're a defendant, no. If you're the person accused of it, probably the smart thing to do after you talk to the detective, and let me back up there, don't talk to the detective. If a detective calls, immediately say, I'm not trying to be rude, I'm not trying to be disrespectful, I'd like to hang up the phone right now and talk to an attorney first, okay? But let's say there was just an introductory conversation, you hang up, that was done. The next thing to do is call a lawyer and say that, listen, I just got a call from a detective, what am I supposed to do? Do I have to cooperate in investigation? If you're the subject of the investigation, the answer is no. If you are the potential victim, you may want to. You may not want to. We have seen these cases over the years. In fact, last year when I was the president of the North Carolina Advocates for Justice, we had a special program here in Charlotte, and we brought in the speakers from the Boston area that actually did a pretty famous movie on this issue. And I actually got to meet one of the main people in the subject of the movie, and he did not want to let his friends know, his family know that he had been subject to some pretty awful sexual activity by someone of trust and authority at a church. And so there are times where if you're the victim of this and police call you, you can say, I understand, I don't want to talk about it. That period is over with. And frankly, that's up to the victim to decide what they think is best for them. The third point is there a way to file suit for the pain and suffering? That's a real difficult one, because there are some statutes of limitations on civil cases that may not apply on a criminal case. So in a criminal case, the police can go after and prosecute somebody until the day they die. There's no statute. On a civil case, there are statutes, and in fact, it's one of the more difficult parts of prosecuting the civil case. Now, there are exceptions. There are exceptions where there was some level of investigation previously, and the perpetrator of the offense hid materials or hid documentation or otherwise made it impossible for you to determine who that was. That may or may not be the case here. Given the age 20 years ago, it's going to be difficult, but maybe not impossible. I encourage a person to sit down immediately with legal counsel, not to let another day go by, and just explore your options. Both on these instances, both on the criminal side and the civil side, if you were the victim in a particular case, at least in our firm, we would not charge anything to come and talk to us. We'd give you a free confidential consultation. We'd kind of want to go over some of the facts, as painful as they may be, in a polite and respectful manner, and tell you what your options are. On a criminal case, again, we don't charge for a consultation on a criminal case. So it's a really, really good question. My heart goes out to the person who wrote this particular type of question. Obviously, they're suffering through 20 years of dealing with this. So thank you for posting it. Thank you for sharing to the extent you did. And if you have questions, we're here to help. 704-342-HELP. My name is Bill Powers, and I help.